Another update on Anne Heche's case resulting from her fatal accident last month. It's a sad update. Nothing really to shed light on any more information related to the accident itself, but some court filings that have been going on recently. Us Weekly Sarah Hearson is reporting that they got documents from Us Weekly. Our eldest son, Homer LaFoon, has filed paperwork to be put in charge of his mother's estate. Apparently, Anne did not have a will and she's intestate. The annual income is listed as unknown by the 20-year-old son, who references 13-year-old half-brother Atlas Tupper in the paperwork also. So her oldest son has filed to be executor of her estate. The estate consists of two intestate heirs, Homer and Atlas. Homer's the adult and proposed administrator. Atlas is a minor. It's filed concurrently with a petition for appointment of guardian ad litem for Atlas, which specifically requests the guardian ad litem be granted the authority to waive bond on behalf of the minor. Now, they put that in the article. I'm sure they don't know what that means, but when they're asking for this type of relief, sometime in other civil cases, they require a posting of a bond by the petitioner, and in this particular case, they're requesting authorization to waive the bond, which I'm sure the judge will do. I don't know a lot about probate. I send a lot of my probate stuff out. I get a lot of questions about probate, and I always send those to the #1 probate lawyer in Florida. So if you need a probate lawyer, let me know and I'll send you to her. Anyway, it's a sad story because she didn't have a will. A lot of people don't have wills, and what it does is it makes it more difficult for their surviving family to settle their estate. Now you look at somebody like Anne, and she probably had a lot of assets. I mean, she was very successful, and she probably had, considerable multiple streams of assets that have to be settled in her estate. And if she had a will, that would all be settled in the will. But since she doesn't, now her sons, one's 20, he's an adult, so not so bad for him, but certainly sad. But her 13-year-old, now those two, it falls on those two to settle the estate. Just a sad situation. Which could have been avoided if she had a will. It's not very expensive to get a will, especially a simple will, and everybody should have one. I have one. Everybody should have one, just so your children and your rest of your family don't have to, go to the courts, go through probate, and all that mess. It just makes it a tough situation just a little bit easier for them. It's bad enough that their mom is no longer here, but now to have to go through this and to argue about the estate and get the estate settled. As long as the two sons are in agreement, they sound like they're the only surviving heirs to her estate. As long as they're in agreement and the guardian ad litem's in agreement with the eldest son, it shouldn't be an issue. It'd be really terrible if they did have an issue and they started fighting over it, but if they don't, it should go fairly smoothly through summary administration. But just do yourself and do your family a favor. Have a will, spell everything out what you want done after you leave this planet, and just try to make it as easy as possible for them. It's particularly difficult when it's an unexpected death such as this. I mean, just that's my advice. Get a will. Get a will. It'll make your family a lot happier, and let them keep those fond memories of you instead of having to worry about what to do with all your stuff and your assets. Thank you for joining me here on The Law and the Life. I appreciate the time you spend with me. I am Patrick McGeehan, and I am your best friend at your worst time. Do you have a will? Well, if you don't, you might want to listen up. Good afternoon and welcome to Law and Life. I'm your lawyer, Patrick McGeehan, and I am your best friend at your worst time.